honored today to,
There we go.
so there's the recording. So we're very pleased today to have Rich Christiansen, a partner in the EES group at Kilpatrick Townsend, with us today. So Rich is a patent prosecutor, and he focuses on a broad range of technologies, electronics, medical devices, computer software. Rich undergraduate degree is in mechanical engineering, and he has a JD law degree from New York University. And today, Rich is going to talk to us about ethical conundrums and pitfalls for the unwary. So this is an ethics seminar, and we get ethics credit. Yay! And so, Rich, without further ado, I'll let you have the floor.
Sounds good. So thank you so much for the chance to speak to you all today. So we're going to focus on ethical issues that are particularly relevant to in-house counsel. Now, I've been present in lots of different ethics presentations, and I think the thing that has impressed me most about ethics and ethics presentations is usually how dry they are. And so we try to do this presentation a bit different and try to keep it interesting and interactive. In the era of COVID and Zoom, there have been some new challenges in making it as interactive as I'd like, but we're still going to do our best. And also, to keep it interesting, we're going to cover a number of different topics, and we'll be dipping an inch deep into these different topics. And many of these topics are things that I don't see frequently handled, and that makes them also a little bit more interesting. And so these topics include the risks and challenges of in-house pro bono, insider trading, the employer as the client, competitive intelligence considerations, due diligence activities, and intellectual property considerations. Now, pro bono is an interesting topic, especially in the in-house environment. We each have an aspirational obligation to provide 50 hours of legal services in the year. And there are some key elements to this aspirational obligation, many focusing on the recipient of those services. We should provide services to persons of limited means, to organizations serving those persons of limited means. Additionally, we can provide financial support to organizations that provide legal services to persons of limited means. Now, with every obligation, there's an opportunity. And by serving these different groups and people, we have the opportunity to use our legal training to provide meaningful change to a person's life. Through pro bono service, we're able to provide this assistance to somebody in a way that they can't assist themselves. In ways, pro bono reminds me of the story of the boy with the starfish on the beach, where the boy was walking alone along the water and picking up starfish as he found them and tossing them back into the ocean. An old man was walking in the opposite direction, saw the boy doing this, and walked with the boy and asked him what he was doing, and asked if he realized that he couldn't save all the starfish. And the boy thought for a second, then he wisely replied that maybe he couldn't impact and save every starfish, but to the starfish in his hand being returned to the surf meant everything in the world. And with our little 50 hours of pro bono service a year, we can't change everything. We can't right every wrong and undo every injustice. But for the people that we're helping, we can provide that little service, that little assistance that maybe makes a big difference in their life. Now, you might say, I'm busy. Why would I spend my time on pro bono? And it's a fair question. There's a number of answers. First, take a second and remember back to why you went to law school. I think most of us didn't go to law school so that we could be one of a large number of attorneys in an in-house department or at a large law firm. We went to law school with the romanticized dreams of helping the downtrodden, maybe representing some interests that we care deeply about, and really making that impact. And one of the downsides of working for a big firm or for a big company is that it's easy to become cynical about the impact and importance of the work we provide. But through pro bono, we can really capture a portion of that vision that inspired us to enter this profession in the first place. maybe putting it a different way and taking us back to the late 90s, there's a scene in the movie Jerry Maguire where Tom Cruise and Cuba Gooding Jr. are talking in a locker room. Tom Cruise is playing Jerry Maguire, and he's asking Cuba Gooding Jr., who's playing the NFL wide receiver Rod Tidwell, what he wants from his career. Cuba says that he doesn't just want the money, but that he wants the quan. And he explains that the quan is the money, it's the community, the appreciation, and the respect, all rolled into one. And viewing our legal careers as a whole, sometimes parts of those aspects of the quan are missing in our main jobs, but through our pro bono services, we can recapture that aspect and add some more meaning and purpose to the work we provide. Now, there are several potential ethical issues relating to pro bono work. The first is whether we are able to provide legal services in the state in which we currently reside. Now, this isn't as much of a concern for people in private practice, but it is more of a concern in the in-house environment, where it is increasingly common that people are serving as in-house counsel in states other than where they took the bar. And so if you are not barred in your current state of residence and in which you are in-house counsel, that can be an obstacle to providing pro bono service. So almost half of jurisdictions are silent as to whether non-locally licensed in-house counsel may provide pro bono services. Interestingly, those jurisdictions that aren't silent don't often provide freedom to provide those services, but they provide restrictions. Generally, these restrictions require an unlicensed in-house attorney to provide legal services, so pro bono legal services, in association with an approved legal organization, usually a legal aid organization, and under supervision. Now, California has an interesting approach to this problem of non-California licensed in-house attorneys and provides a pathway for non-California licensed in-house attorneys to register as in-house counsel. So they created kind of a separate category of attorneys, and that's a registered in-house counsel. Now, Rule 9.46, California Rule 9.46, outlines what a registered in-house counsel can do. This rule is lengthy and detailed, and we're not going to go into all the details of that rule. We're merely going to focus on the fact that under Rule 9.46, a registered in-house counsel is able to provide pro bono services when they're under supervision of a California attorney, and they're providing those services for either an eligible legal aid organization or providing the pro bono services through that in-house counsel's employer. So while California places significant restrictions on pro bono practice for non-California registered in-house counsel, there is a pathway for those attorneys to provide pro bono service. If you are in-house counsel in California and haven't taken the bar here, you should review these rules to see how you register as an in-house counsel and the limitations and abilities to provide service under those rules. Another potential snare in pro bono service arises with respect to conflicts of interest. As said in ABA 1.7, a conflict of interest can arise whenever one client is directly adverse to another client, or two, whenever there's a significant risk that the representation of one or more clients will be materially limited by the lawyer's responsibilities to another client, a former client, a third person, or by a personal interest of the lawyer. Now, these conflicts of interest can make it difficult for an attorney to fulfill their obligations. Additionally, with respect to conflicts of interest, even the appearance of impropriety is sufficient to create that conflict. Now, you might say, if I'm providing pro bono services, how would that create a conflict of interest with my in-house employer? And maybe think about that for a second. Think about scenarios where there may be a conflict arising from that pro bono service. And as I sat and thought about some of these different scenarios that could give rise to a conflict of interest, many of them were not necessarily tied to the work being provided, but were arising due to the relationship between the pro bono client and the in-house employer that may be pre-existing. Some of the scenarios that came to mind that could give rise to a conflict relate to issues of product liability or contractual disputes. And maybe if somehow our in-house employer provides sufficiently low compensation that somebody qualifies for pro bono services from a legal aid organization, employer-employee issues. So since there are a number of ways that this conflict could arise, it seems that conflict of interest in the pro bono context isn't just a throwaway concern, but that it could actually be an issue that we need to be aware of. So given that this risk exists, then how do we mitigate the risk? And there's a couple different ways of mitigating that risk. One way to potentially limit the risk is by exercising caution in the type of pro bono cases that you accept. For example, as I was thinking about this, the number of scenarios giving rise to a conflict of interest seems smaller with, for example, a pro bono client that is being helped with an adoption proceeding as compared to a pro bono client being helped with the prosecution or drafting and filing of a patent application. So compared to adoption, it's far easier to imagine how conflict of interest could arise in the context of helping a client with a patent application, for example, through the USPTO's patent pro bono program. So given the requirement, so if there is a conflict of interest, there are ways to continue the representation. And so you can see on the screen, we've got Rule 1.7b and its subsections there. But given that subsection 4 requires that each affected client gives informed consent, the hurdle to continuing representation if a conflict of interest exists is fairly high, and it's easier just to avoid the conflicts in the first place. And so as mentioned, one way to do that is by being careful about the kind of matters and kinds of pro bono services that you provide. Another potential way to limit the risk of conflicts is to limit the scope of the representation. In fact, ABA Model Rule 1.2 explicitly indicates that a lawyer may reasonably limit such representation and says, a lawyer may limit the scope of the representation if the limitation is reasonable under the circumstances and the client gives informed consent. So the limitation on the scope of services can identify specific actions or services being provided or a specific time frame. In the context of pro bono patent programs, this frequently involves indicating that the representation is only for the completing of a single action, such as drafting and filing a patent application or responding to an office action. Such a limitation on the scope of representation clearly indicates that the representation automatically terminates upon completion of that action. And that is an important thing to keep clear there, is that the representation automatically terminates so that you don't end up in a situation where there is an argument that the representation is still ongoing. So through a limitation of scope or a limitation on the scope of representation, you can protect yourself from mission drift and expansion that could lead to a conflict. Another issue relevant to providing pro bono services relates to competence and diligence. In a little twist of irony, it seems that circumstances that may minimize our risk of conflict increase our risk relating to the duties of competence and diligence. As with any other work, we're obligated to provide competent and diligent representation to our clients, even to our pro bono clients. And that obligation doesn't shift if a client is a pro bono client versus a paying client versus our employer. The obligation is always the same. And this obligation presents two challenges. The first is, are we competent to provide the pro bono services needed by our pro bono client? This includes the question of whether or not we're getting the training and support needed to competently represent the pro bono client. Many legal aid organizations provide training to remedy this. And so if you are providing pro bono services through one of these organizations, make sure you're taking advantage of this training and that you're being self-aware enough to recognize when the tasks that you have to handle are outstripping your knowledge, your competence, and the training you've received. And when that happens, make sure to ask for help. The other part of the obligation is the obligation of diligence. And for this, the question is, do we have too much on our plates to allow us to diligently represent the pro bono client. The obligation to be diligent can be challenging, especially when the pro bono matter extends over a long period of time. To ensure that we are fulfilling these obligations, you should make sure that you're able to dedicate the time required by a matter in advance of taking the pro bono representation, and constantly check in as to your continued ability to provide diligent representation. Applying this to the pro bono patent context, it's easy to agree to write an application for a pro bono client, but then as other tasks mount up, it's easy to let that slip and to prefer the work for your employer or for your other clients. But that's in violation of the obligation. We have to represent our pro bono clients with the same competence and diligence as we do every other client. And so really, it's when you're taking on a project, especially if it's a big project, you need to be honest with yourself and honest about your time and your willingness to push through and get something done. But you need to make sure that you will be diligent in that representation. Now, shifting gears a bit, we're going to now discuss insider trading. Recently, the SEC has been increasing prosecution of insider trading by in-house attorneys. As such, there have been several high-profile prosecutions of insider trading in recent years. This includes both Bay Area prosecutions for an attorney at Apple, and for us down in San Diego, the prosecution of the Inhouse Counsel at SeaWorld. In each of these cases, the in-house attorneys misappropriated confidential information and then made trades based on that. The behavior of the Apple attorney was particularly egregious and even reached the point of being comical, as this attorney was responsible for ensuring compliance with Apple's insider trading policy. And so as such, he was acutely aware of Apple's insider trading policy and how to avoid violating insider trading rules. But in spite of that knowledge, he proceeded to buy or sell stock in blackout periods, and he got caught. And so at some level, and this is the challenge with all ethics or with all ethical issues in life. Once we know the rule, the question is, do we have the integrity to follow through and live up to the ethical obligations that we have? And I think in this case, we have an instance where we had an attorney who is very, very aware of their ethical obligations, but who just got a bit greedy. In the case of the SeaWorld attorney, it's less egregious, but in some ways it's a little bit more. It almost feels like the story of a National Enquirer, because SeaWorld had some ups and downs associated with issues relating to the treatment of animals and documentaries coming out. And at some point in this, when everybody was expecting SeaWorld to start falling apart at the seams, they had a very good year, and their in-house counsel took advantage of that. I guess, again, he got greedier than his level of integrity. So the last case here on the slide relating to the Cintas Corporation is particularly interesting given the changes in practice and in life since the start of COVID. And maybe over the next year, this will become less relevant as our lives start shifting back to normal and we start returning more to our offices. But there are still some issues there that we should be aware of. And in this case, the Cintas in-house counsel, he was victimized by a lifelong friend who was a guest at his house. And so this in-house counsel had, when he worked at home, he'd bring papers home from the office, and he had an office at home. He'd put them on his desk, and then he'd work on them throughout the night. And some of those papers were confidential and had confidential information on them. And, during some period of time, he had a friend come over to visit, to spend a couple of days with him. And that friend saw the papers on the desk and appreciated that there was something valuable and confidential in them. And based on the information he gleaned from seeing those papers and from later sneaking back and getting access to those papers, this, maybe I should say friend, traded stock and took advantage of the friendship there. So with that scenario, that raises the question of how are we handling and securing our workplaces? How are we securing our at-home workspaces? Are we doing things to make sure that our confidential papers aren't accessible, that they're not just thrown away in our trash cans, and that our devices are secure? It turns out, even with people that we think we should be able to trust, sometimes levels of greed exceed their integrity too. And we are better off, and we should be protecting our clients and our employers and their confidential information. Now, this case here, US v. Klein, is a blatant example of stereotypical insider trading by an attorney. But one thing that's interesting about the case is almost the triviality of the statement that gave rise to the finding of guilt here. So in this case, the attorney, so Robert Schulman's a law firm partner, and he hired a man named Tiber Klein to manage his IRA. In his work at his law firm, Robert Schulman received confidential information regarding a possible merger with King Pharmaceuticals. And maybe this is the message from all these insider trading stories. So at the time, Tiber was staying with Robert Klein. And so this conversation between the two that gave rise to liability happened later that night while spending the night. And so in some ways, this is similar to the Sintas fact pattern. But anyway, so after Robert received that confidential information, and the next time that Tiber was over at his house, Robert Klein mentioned to Klein, it would be nice to be king for a day. Now, maybe there was more context to that statement, maybe there was more conversation, but the court record points to that statement and says that based on this statement, Tiber knew that he should buy shares of King Pharmaceutical stocks. And so he bought approximately 600,000 shares of the King stocks. And then Klein and his contacts sold those shares 2 months later after the merger and for approximately 50% ROI. And so that last bullet point, the court found that Schulman expected Klein to use non-public information in securities trading. And I think for me, like I said, I imagine there is more context to that statement, but in the record that I read, I wasn't seeing that context there. And it goes to show you how cautious we need to be with the confidential information that we have in really protecting, like I said, protecting our clients' interests or protecting our employers' interests. Now, so some takeaways for insider trading. Be cautious when trading your company's stock or stock in your industry. Follow your company's trading policies, and then maintain good security hygiene. And that includes device security, communication security, and security for your paper documents. So another potential risk for in-house attorneys comes from their relationship with their employer. While this may not always be viewed as an attorney-client relationship, there are circumstances in which a court will brush aside titles and find that relationship. So this case here, KV Rosafielda, is now several years old. And so far, I haven't seen any indication of there being a strong move to apply this reasoning to a large swath of other circumstances. So as of now, this is an outlier, but this outlier goes to show you that under certain circumstances, certain egregious circumstances, the court will brush aside titles for in-house counsel and will find that attorney-client relationship and will impose the obligations of that attorney-client relationship. Now, so in this case, the defendant employee, Alan Rosafielda, was hired as the COO and functioned as the GC for some of Bruce Kay's companies. And Bruce Kay, he had these 3 entities that sold and managed timeshares. And despite the fact that Alan Rosafielda received a $500,000 salary, he partook in self-dealing and other activities, including forging real estate documents, creating corporate entities without Bruce Kay's knowledge or consent, and giving himself 20% interest in those entities. And then something that I thought was kind of an interesting fact, given the other things that Alan had done, but the thing that apparently really irked Bruce was that Alan charged $4,000 for a corporate trip to Las Vegas. I think there is a lesson in that right there for dealing with our employers and clients, as to knowing what crosses the line and what really for the client is important or for your employer is important. But that's probably a separate conversation. So when Bruce K. learned of this misconduct by Allen, he sued for breach of fiduciary duty, legal malpractice, breach of loyalty, and unlicensed practice of law. The big question in this case was the applicability of rules 1.7 and 1.8. So rule 1.7 relates to conflicts of interest, and rule 1.8 relates to business transactions with your clients. So Alan Rosefielde, our offending attorney, argued that he was operating in a business capacity and not in a legal capacity, and so that these rules didn't apply to him. Well, this argument was factually accurate. The court found his behavior so egregious that they were willing to overlook the details of his role. So they found that that his interactions with Bruce were as if Rosefielde was an attorney, and that Bruce K. and his companies relied on Rosefielde's legal guidance. And so because of these two things, the court found that Alan Rosefielde violated Rule 1.8. And so this is where it gets interesting. So the court found that there was no rational basis to exempt an attorney who has been hired by corporate clients to serve as in-house counsel from the ethical obligations of Rule 1.8. They additionally applied rules 1.5 and 1.7 to Rosefielde's circumstances, finding that he was overcompensated and thus that he violated Rule 1.5. So like I said, this decision's an outlier, but as one moves up in a corporate structure, one likewise becomes an outlier. Or if you're the only attorney at a very small startup, you're putting yourself in an outlier situation. And this outlier status seems to be particularly risky when an attorney's role in a company is such as to require or to give them, as to require the special negotiation and or agreements relating to a compensation of that attorney. So anytime you find yourself negotiating special compensation for yourself with your employer in an in-house role, you are exposing yourself to this kind of risk that a court may look past the business relationship and find an attorney-client relationship. So a takeaway, and as I mentioned, and saying it again, this case is an outlier. But if you are in the role of an outlier, become more cautious in how you interact and negotiate with your employer. Let's go back. So some things to think about. If you're in that role, you may want to advise your employer to have separate counsel review any contracts coming out of that negotiation, things of that nature. So again, if you find yourself in a position where you're negotiating things like compensation with your employer, be cautious, because courts in outlier situations, or at least one court has found that even in a pure business relationship, there can be an attorney-client relationship and the associated obligations. So another area of risk relates to the collecting of competitive intelligence. This risk relates to how you go about gathering this information and ensuring, to the extent that you are gathering information from others, that you do not make any misrepresentation, including about who you are. So similarly, risk can arise in the due diligence context. This can be challenging because of how we're obligated to protect confidential information, but also because we're simultaneously obligated to be a zealous representative of our employer. This raises challenging legal questions, or challenging questions like, how do we turn off knowledge? So this case is an interesting case. It's an example of an individual who strayed from his ethical obligations. So Merck in-house counsel was part of a deal team, and he later used previously filed patent applications to target the entity that was on the other side of that deal. So it starts out, so the first bullet point, so Merck filed broad applications for HCV and for treating HCV. After that, Pharmasset and Merck discussed potential collaboration. And Merck agreed to provide a demanded firewall. And Merck then placed Dr. Durrett, who was part of the HCV team and the prosecutor of the HCV patents, on the Gilead call. And so we're changing some names here. Pharmasset was acquired by Gilead. So after he participates in this call, Dr. Durrett quits the HCV team, but he maintained his role as prosecutor of the patents that he previously filed. And then he later wrote claims targeting Pharmasset or Gilead. Then after that, Merck sued Gilead, that by now had acquired Pharmasset, for patents filed by Dr. Durrett and that had claims written targeting the Gilead Pharmasset product. So the court held that the patents were unenforceable against Gilead due to business conduct and litigation misconduct. And in something that's interesting, they found that the inequitable conduct that gave rise to the unenforceability of the patents was outside the scope of Theracense. It's interesting. So you start really digging into the details of this case, and there's a couple of interesting things that come up. One arises due to the fact that Merck had previously filed these patent applications before they had contact with Pharmasset. And so they had a priority date that predated any confidential information they received from Pharmasset. But what the court found is they found that the business misconduct provided a litigation benefit. And they said because they knew what Pharmasset was doing, they were able to write narrow claims targeting that, which expedited prosecution and decreased the risk of invalidity. And they said that those benefits immediately and necessarily tied the business misconduct to the equity of obtaining enforcement. Now, and I think this is interesting because in the scheme of misappropriating information, this seems far less nefarious than taking information and filing a patent application on it. And so it's interesting to see a court find that even misappropriating information for the sole purpose or for the benefit of expediting prosecution is enough for claims to be unenforceable. And it was also interesting to see them find this outside the scope of Theracense. And they said this was outside the scope of Theracense because the inequitable conduct wasn't based on statements to the patent office. It was based on their business misconduct. So maybe going back to this, so when you're in these situations, when you're in situations receiving confidential information, you should be taking measures and sticking to measures of protecting or for protecting that confidential information, even down the road. Another takeaway that we didn't really talk about much, but our good friend Dr. Durrett ended up lying in his depositions, and that was some of the litigation misconduct. So don't lie when you're being deposed. But I hope you don't need my presentation to know that rule. So then there are some other pitfalls in day-to-day patent work. The times when we sign declarations, fill out USPTO forms, just all these they're just different little actions in which we make statements to the patent office about facts. And those can also all give rise to claims of misconduct and raise ethical concerns. So, one of the first ones is the duty to disclose. When we're prosecuting patents, we have a duty to disclose things to the patent office. And there it says, under 37 CFR 1.56, we have a duty to disclose all known information that is material to patentability. And this duty continues through prosecution until the patent is granted. This duty includes disclosing rejections in co-pending applications. So quoting from the McKesson case, although examiners are not bound to follow other examiners' interpretations, knowledge of a potentially different interpretation is clearly information that an examiner could consider important when examining an application. This McKesson case and the duty to disclose what's going on in related applications or other applications to the examiner, I think becomes particularly relevant to in-house counsel, especially at very large companies. For small clients, or for smaller clients, maybe a single law firm handles all your prosecution. And so then that single law firm has the knowledge to be able to provide adequate disclosure to the patent office. But for large companies or companies employing multiple outside counsel to prosecute patents, do you have systems in place to spread information, to share information, so that your outside counsel is capable of meeting this obligation? Now, declarations are another interesting area. And this case here, I found interesting because it illustrates an affirmative obligation to correct errors in declarations that we become aware of. So in this case, the patent attorney filed the Rule 131 declaration regarding a reduction to practice with USPTO. The attorney later learned that the inventor did not review the declaration and that the declaration contained inaccurate information. But the attorney didn't advise the patent office about the inaccuracy in the information and didn't fully correct the record in writing. And because of that, the patent office found a violation of ethical duties. And so the district court held the resultant patent unenforceable due to inequitable conduct, in part because of the false declaration. And then we have, we must expressly advise the patent office of the existence of misrepresentation, stating specifically where that misrepresentation resides. We need to make it clear that further examination may be required if PTO action is based on the misrepresentation, and it doesn't suffice to merely supply the office with accurate facts. So we can't just file a correct declaration. We need to affirmatively call out the mistakes, the errors in the previous declaration to correct the record. And for his error, this attorney had a 4-year suspension, but he was eligible for reinstatement after 2 years. So this brings to end the first portion of the presentation, and now we're going to shift into the scenarios. So just a little bit of background. Initially, when I created this presentation, the first couple times I gave this presentation, it was pre-COVID. And so in those circumstances, what I would do is I'd divide the room up into different small groups and we'd work through the scenarios. That doesn't work very well with Zoom, so we're going to do things a little bit different. What I found works pretty well is I'm going to give you a couple minutes to read through one of the scenarios, and then I'll highlight some of the parts of that scenario, and then we'll talk about different ethical issues that arise. After we go through the scenario together, I'll open up the floor. If you have comments, if you identified any ethical issues, point those out and we'll talk about them. And that's how we'll handle that. So this first scenario, it's based loosely on facts of a real life scenario. And so this is scenario 1 in your paper. I'll give you a couple minutes to read that. Give you about 30 more seconds. Okay, so scenario one, it's something where I almost have some empathy for the prosecutor, but just seemed to go a little bit too far. So it says here, Alexander Smith, he's a registered patent attorney and an associate at a small firm. He filed a patent application and he received a rejection, an office action with rejections, including rejections under 101. And this is where this scenario gets interesting. He requested an in-person interview with the examiner. And during the interview, he berated and insulted the examiner for rejecting the application. About 2 months later, he filed a response to the office action. And the response didn't include any claim amendments and 5 pages of remarks that didn't address the rejection, but stated, "Are you drunk? No, seriously, are you drinking scotch and whiskey with a side of crack cocaine while you examine patent applications?" So the examiner forwarded that response to the Office of Enrollment and Discipline and issued a notice of non-compliant amendment. So this is where it also gets interesting again. So Mr. Smith didn't report the notice of non-compliant amendment to his client, and he didn't make any other filings in the application. And then the application became abandoned. So on May 5th, 2013, the Office of Enrollment and Discipline issued a 6-month suspension. And then a couple days later, the managing partner of his firm, David Jones, approached Mr. Smith with the opportunity to establish a trademark practice where Mr. Smith would be the sole trademark attorney and would be practicing under the supervision of Mr. Jones. So Mr. Smith's first assignment was to represent Pierce & Pierce, his previously mistreated client, in an oral hearing before the Trademark Trial and Appeal Board on June 10th. So while he's still suspended. So because he was still suspended, he attended the oral hearing under the name of Mr. Jones. And then he ended up losing that, or he was not successful. And the Trademark Trial and Appeal Board issued a decision rejecting the application, to which he fell back into his old habits. Mr. Smith fell back into his old habits and left a voicemail message for the ALJs, cursing and referring to the judges as imbeciles, worthless, and idiots. So with that said, so what ethical issues did people see here? Did you all see here? And feel free to unmute yourself and provide your thoughts.
All of them?
Yeah, there's quite a few. This guy was a character.
Well, hi, this is Joe. Well, with respect to, I guess the first incidents of, basically disparaging the patent examiner as well as the patent examiner's work product, that basically is against the rules, right? You have to treat the patent examiner with respect, and that basically violates that rule.
Yep. Yeah, that's a big one. And he managed to pull that off twice, berating the examiner and then the ALJs. Another one is, and this isn't so much his violation, but you wonder if he was an associate, where was the attorney that was supervising him? You have this going on in an interview, you have a non-responsive amendment filed, then you have him not reporting out the non-compliant amendment or making any further filings. And so, we have as partners or managers or supervisory practitioners, we have certain obligations, and those weren't met. Also, in those same things, you know, in that response that didn't address rejections, there is at least evidence of a lack of competence. Did anybody else have any other thoughts?
He failed to keep his clients informed of developments in the case. He failed to exercise diligence, I would say, in following up on the notice of non-compliant amendment.
Yep.
I'd say he probably failed to inform Pierce of material developments a second time when he came in to represent them the second go around, although that may just be a continuation of his first breach.
Yep. And I think there's also a fun violation of the duty of candor towards the tribunal and him lying about his name and who he is. So I just.
And probably the unauthorized practice as well.
Yep. And so, yeah, so you know, we have some misconduct under, you know, for the patent obligations under 37 CFR 11.804. And we have duties of disciplined practitioner, competence, communication, candor toward the tribunal, responsibilities of partners or supervisory lawyers, and all kinds of good stuff. I mean, this guy really was a piece of work. So let's move on to the second scenario. And this is probably my favorite of all the scenarios. So I'll give you a couple minutes to read that. I'll give you about 30 more seconds. Okay, so this scenario here, we've got Jimmy McGill, who used to work as the criminal attorney for infamous meth cooker Walter Weiss, but he corrected course and he's now a family law partner at Chapman and Becker. He's a very aggressive attorney. And one day a new client shows up, Sydney Bristow. Now, Sydney is a spy who works for SD6 and is a double agent for the CIA. And she's married to Rafe McCauley, a fighter pilot for the US Army Air Corps, who, like I mentioned, he survived the attack on Pearl Harbor and the Jimmy Doolittle raid. Sydney wants Jimmy to represent her. She's never used Jimmy or his law firm before. And Jimmy knows that getting Sydney as a client could help him attract all the other spies and double agents to be clients. So Sydney wants to file for divorce on the basis of adultery. And she shows Jimmy an anonymous letter she received with a picture of her husband and their nanny in a compromising position. Person wrote, "This has been going on for months. Pics are all over Facebook." And Sydney asked Jimmy to friend the nanny and download the pictures. So because Jimmy has his questionable past, he doesn't trust his own instincts and he comes to us for advice. And he wants to know if he can friend the nanny on Facebook, if he can get his secretary to friend the nanny on Facebook, if he can have Sydney use her husband's account to access the nanny's Facebook page, or none of the above. Does anybody have any thoughts on this?
Sorry, Rich, this is Gwen, but she must be a terrible spy if she couldn't come up with this information on her own. In any event, and poor Jimmy, I don't think his judgment has improved much if he's excited about getting a whole battery of spies as clients. But I think that, in my view, I look at the 4 choices and I'm like, well, none of the above, right? I mean, he shouldn't be doing any of that just ethically. And there might be, I don't know, there might be some sort of legal way for him to do it. But I just, I think that, kind of the common sense answer for me is answer D, none of the above.
Mm-hmm. Any other thoughts? Yeah, and I think looking at this, so rule 8.4, is applicable to all of these, and it says it's professional misconduct for a lawyer to violate or attempt to violate the rules of professional conduct, knowingly assist or induce another to do so, or do so through the acts of another. And so to not violate the ethical rules, the lawyer themselves can't violate the rules, but they also can't have somebody violate the rules for them. And so so just looking at option A, so the nanny doesn't, or at least we don't have any information about the nanny being represented by counsel. So rule 4.2 is not applicable. That rule says in representing a client, a lawyer shall not communicate about the subject of the representation with a person the lawyer knows to be represented by another lawyer in the matter, unless the lawyer has the consent of the other lawyer or is authorized to do so by law or a court order. So Jimmy could contact the nanny by Facebook, but if he does, he can't misrepresent and mislead pursuant to rule 4.1. In the course of representing a client, a lawyer shall not knowingly make a false statement of material fact or law to a third person, or fail to disclose a material fact when disclosure is necessary to avoid assisting a criminal or fraudulent act by a client, unless disclosure is prohibited by rule 1.6. So Jimmy could approach the nanny and say, hey, I'm representing Sydney Bristow in a divorce case where she's trying to divorce Rafe on the basis of adultery. Can we be friends? So option A, we have very limited circumstances. They're a very small pathway to do that. For B and C, we kind of have the same issues arise where under 8.4, Jimmy himself can't break ethical rules, but he also can't have somebody else break the ethical rules. So he can't have his secretary misrepresent who he is to become a friend. And he can't have Sydney access the nanny's account via her husband's account, if that's not something Jimmy would be allowed to do. So based on all that, the closest correct answer is D, like you said, but with the caveat that if the information is publicly accessible without friending the nanny, then it's fair game. And I think your point's taken. I don't know that Jimmy made a wise move shifting from representing meth dealers to representing spies.
So Rich, just given the time, maybe we should just do the last scenario, or one more scenario, and then wrap it up.
Sounds good. So then I'll give you a couple minutes to read this third scenario. I'll give you about 15 more seconds. Okay, so here we have a litigation associate at Chapman and Becker named Divya Singh. She's assigned to an employment discrimination case with a client, Karen, who's a pregnant woman who was recently dismissed from her job. Karen's former boss, Deep Singh, says that Karen wasn't fired for being pregnant, but that the firing was performance-based. The company does not have a formal review process, and so it's essentially your client's word against Deep's. Divya and Deep have the same last name. In the past, the opposing counsel once mistakenly sent Divya an email intended to be sent to Deep. Now, late at night, Divya receives an email from opposing counsel. And when she opens it, she realizes again that it's meant for Deep. And the email states, Deep, please review ASAP the attached document. It outlines the reason we could very well lose this case to Karen, as well as our previously discussed settlement strategy. So what should Divya do? Should she delete the email? Should she forward back the email without opening the attachment? Should she read the attachment and delete the email? Should she read the attachment and notify opposing counsel of the misdirected email? Or should she call the opposing counsel and ask him what to do? What do y'all think? And I think this is a really tough scenario. So the only action required to be taken under the rules is to notify the opposing counsel. So Rule 4.4b states, a lawyer who receives a document or electronically stored information relating to the representation of the lawyer's client and knows that the document was inadvertently sent shall promptly notify the sender. So comment 2 of the rule explains, paragraph B recognizes that lawyers sometimes receive a document or electronically stored information that was mistakenly sent or produced by opposing parties or their lawyers. A document or electronically stored information is inadvertently sent when it is accidentally transmitted, such as when an email or letter is misaddressed, or a document or electronically stored information is accidentally included with information that was intentionally transmitted. If a lawyer knows that such a document or electronically stored information was sent inadvertently, then this rule requires the lawyer to promptly notify the sender in order to permit that person to take protective measures. The comment to Rule 4.4 goes on to state that whether the lawyer is required to take additional steps, such as returning the document or electronically stored information, is a matter of law beyond the scope of the rules, as is the question of whether the privileged status of a document or electronically stored information has been waived. And so this becomes a really challenging scenario when you think about obligations you may have to the client, and the fact that litigation and transactions aren't single event games, but that those relationships continue on. But according to the rules, the only obligation is to let the sender know that the email was misaddressed. And with that, since we're out of time, are there any quick questions? Otherwise, I'll hand the time over to you, Joe.
Well, thank you, Rich, and thank you very much for giving us such a interesting discussion period as well as presentation. We appreciate your efforts, and that will happen. And thank you again.
Thank you.